welcome to the first half of Professional Responsibilities module. So today we'll begin with regulation of the profession. So you know your license to practice is issued by your state board. State boards have oversight and they have the power to even suspend or revoke a CPA's license. So even though your license is issued by the state board, all CPAs pass the same exam. So in other words, it's important for you to learn the majority rule. You should also know the laws in the state in which you live, but the CPA exam focuses on the majority rules. To audit public companies, the firm has to be registered with the Public Company Accounting Oversight Board. So let me tell you, before we even begin, I will admit that I do not know all of the acronyms for your profession by heart, but I'll try to do the best I can as we go through this. Your Code of Professional Conduct is actually adopted by your state board. And even though there are 50 different state boards, they're very similar. So because they're based on the AICPA Code of Professional Conduct. Remember, your state board's Code of Conduct sets minimum standards by which you are to conduct your professional life. It applies to all CPAs, even non-members. The Uniform Accountancy Act did a lot of things. It's a model act that was developed by the AICPA. It says a few things that you need to remember, that state boards are the boards that issue credentials, and the UAA also establishes certain ethical provisions regarding confidentiality and working papers. Today we'll talk a little bit about confidential and privileged communications. Working papers, that'll be next class. Substantial equivalency, so it has a provision in it that promotes interstate practice. So unlike lawyers who have to be licensed in every state in which they want to practice, an accountant would not need to be because of the substantial equivalency. We want the free movement of accountants between states. It also has some continuing education and peer review provisions. The only professional services that you are required to be licensed to perform include, so if you're going to do any sort of attestation services, you need to be properly licensed, or to create a compilation of financial statements, you would have to be properly licensed. So let's look at a couple of questions. The first one, which of the following bodies issue permits to practice for CPAs? And that is your state boards of accountancy. And then the second question, which of the following is not an accurate statement about the requirements of the AICPA Uniform Accountancy Act? And it is A. The UAA requires all accountants to be licensed. That's not what it does at all. So, disciplinary systems. The AICPA Code of Professional Conduct is enforced by the PEEC. The JEEP allows for joint investigations. So an investigation, let's say the AICPA is doing an investigation and a state board is doing an investigation. The JEEP allows for joint investigations of the same person. Possible sanctions, admonishment, which is essentially a public embarrassment, slap on the wrist, whatever you want to call it. Corrective action, which is oftentimes does happen. Suspension or even expulsion from the profession. A member may be expelled without a hearing if the CPA certificate is revoked by a state disciplinary board. Again, that would be for very serious misconduct. Or if you've been convicted of a crime punishable by more than 1 year in jail. If you've been convicted of a felony, in other words. If you filed or aided and abetted in filing a fraudulent tax return either for yourself or for a client, or if you've intentionally failed to file your own tax return. Securities Exchange Commission may revoke a CPA from practicing before that agency for willful violations of securities laws and regulations. By the way, you will not be practicing in the area of securities regulations unless you have a rider on your malpractice insurance that specifically grants you permission to practice in that area. A crime involving moral turpitude lying, cheating, stealing, committing fraud. For committing a crime involving moral turpitude, and the SEC can ban a CPA from practicing for either a felony conviction or a misdemeanor if it happens to be a crime involving moral turpitude. Again, lying, cheating, stealing, fraud. Fines and penalties may be imposed by the Securities Exchange Commission. Disciplinary actions against a firm. I bet you didn't know this. A state board may bar an entire firm from practice. The SEC can ban a firm from doing work for a public company. Firms have to be registered with the PCAOB to perform audits or reviews of financial statements for public companies. So if a firm has 100 or more public clients, they must be inspected annually. And if there are fewer than 100 clients, then they must be inspected every 3 years. All right, so here are your questions. Which of the following is not a possible result of an AICPA investigation of a member for an ethics violation? Which of the following is not? And so the answer is A, revocation of right to prepare tax returns. You can always go down and work for H&R Block, I suppose. So 4, which of the following may not result in automatic expulsion from the AICPA? Now this is kind of a trick question, so this is one of those questions that I'll point out. You should read the entire answer, and the answer to this question is D, conviction for a felony or a misdemeanor. So there's not automatic expulsion without a hearing for conviction of a misdemeanor. Felony, yes. Misdemeanor, no. 5, a member of the AICPA is convicted of filing a fraudulent tax return. What is the likely consequence of this action? The likely consequence is that you're going to be expelled or suspended from membership in the AICPA. Common law liability. You can also be liable under the common law. So remember, the common law is what our system of laws is based on. Every state's system of laws is based on the English common law, with the exception of Louisiana, and that's French law or the Napoleonic Code or French civil law. So common law liability is based on case law, and there are a couple of different ways that you could be held liable under the common law. You could be held liable for breach of contract. And to be held liable for breach of contract, you have to be in privity of contract with your client. That you could be held liable for negligence, that is failing to do what a reasonable accountant would do under the same or similar circumstances. And again, for negligence, there has to be some sort of a privity-like relationship. Or under the common law, you could be held liable for fraud. So breach of contract. The good news is this: your contract with your client is usually your engagement letter, so you should carefully craft your engagement letter. Privity of contract simply means you're in a relationship with another person in a contractual relationship, so an accountant and their client are considered to be in privity of contract. A breach of contract occurs when the CPA fails to perform substantially as you'd agreed. You have an express duty to perform your duty as you have agreed to perform it. Or it could also be a failure to exercise due care, and this is an implied duty under your contract. You impliedly agree that you will exercise due care to fulfill your contract with your client. My note to you is this, because sometimes this is asked on the CPA exam: an accountant is generally not liable for failing to detect all fraud in a normal financial audit or a review. Sometimes you could have a contract that is a time is of the essence contract, and if you do, you could forfeit your right to compensation if you do not perform your contractual duties in time for the contract. If you, as a CPA, if you issue a late opinion because the client has failed to supply information that you need in a timely manner, then you are entitled to payment in full. Time is of the essence contracts are fairly rare, and it has to be stated in the contract that it is a time is of the essence contract. tort liability or negligence. So there has to be a breach of a duty of care that an accountant knows the client, and that breach must be the proximate cause of damages. So liability for negligence, you need to know this standard, is when there's a failure to exercise due care. In other words, you owe your client the degree of care that is commonly possessed by members of your profession. This standard, of course, is going to be guided by several things. So state and federal statutes, case laws, your contract with your client. But again, the standard of care is what would a reasonable accountant do under the same or similar circumstances. What about GAS and GAP? Well, failure to follow GAP is persuasive but not conclusive evidence that you've been negligent. Failure to follow GAS, on the other hand, is conclusive evidence of your negligence. So, does this mean that compliance with GAS is going to absolutely insulate the auditor for liability for negligence? And I answered my same question that I asked. The answer is no. Although compliance with GAS is a persuasive argument that due care is present, the courts could find that the accountant is still negligent. And of course, we look at customs of the profession, and this is a relevant argument, but not conclusive. Question 7, which of the following statements best describes whether a CPA has met the required standard of care in conducting an audit of a client's financial statements? And so the answer is C, whether the CPA has conducted the audit with the same skill and care expected of an ordinarily prudent CPA under the circumstances. So the next question is also a standard of care question. So when performing an audit, a CPA must exercise the level of care, skill, and judgment expected of a reasonably prudent CPA under the circumstances. 15, a CPA's duty of care to a client most likely will be breached when a CPA D, fails to follow generally accepted auditing standards. Confidential versus privileged. All right, so a lot of people don't understand this, but you would only have privileged communications with a lawyer, a doctor, or your priest. Generally speaking, you do not have privileged communications with your accountant. Are they confidential? Yes. Are they privileged? No. This means that an accountant may be subpoenaed into court and have to testify under oath as to what their client told them. The only way an accountant would have a privileged communication, that is one where you cannot be compelled to testify against your client, would be if there is a state law that specifically recognizes the accountant's client privilege. The communication must be intended to be confidential, and there's no consent to testify. So again, what you tell your client and your conversations with your clients generally are not privileged. Yes, they're confidential. You're not supposed to tell anyone else, but if you're subpoenaed into court, you may very well have to testify as to what your client told you. Liability for fraud. So the elements of fraud, there must be an intentional misrepresentation, that's scienter, right, of a material fact, justifiable reliance thereon to the detriment of the relying party. In other words, there need to be damages. Punitive damages may be available if there is fraud. Scienter, or intent to deceive, may be satisfied if there is reckless disregard for the truth. This is known as constructive fraud, and oftentimes appears on the CPA exam. Common law liability to third parties. We could get bogged down in this. This is the Ultramar's decision. I've given you the Cliff's Notes version of the Ultramar's decision on this slide right here, which you can read on your own. But the Ultramar's decision is an old one from 1925. It was ultimately decided by a very famous judge. His name was Judge Benjamin Cardozo. And he held this, that if an audit is as in this case, negligent, the accountant is liable not only to the client, but may be liable to someone who is a foreseen third party. So this foreseen third party, there has to be a special relationship or a privity-like relationship created. So there, in terms of the requirement of privity, it's not contractual privity, but a relationship that is mighty close to being a contractual relationship. This is a minority view, and so what I will tell you is that the majority rule now is perhaps to hold accountants liable even in more cases than with the Ultramayor's decision. Courts have expanded liability to other third parties. An accountant may be liable to foreseen third parties, that is, you know someone else is going to rely on your work for ordinary negligence if the accountant knew they would rely on the financial statements. So if the accounting firm simply knew that their work would be relied on to secure financing, then the accounting firm is liable for negligence to the lending institution. However, what would happen if the audited financial statements were given to trade creditors or perhaps potential investors? In this case, trade creditors or potential investors are not foreseen, but they are foreseeable third parties, and the accountant is not liable to foreseeable third parties. 2 questions. You can look at these in your book and read over the answers. 17, if a CPA recklessly departs from the standards of due care when conducting an audit, the CPA will be liable to third parties who are unknown to the CPA based on gross negligence, if there's gross negligence or fraud, so that's B. And then 18, in a common law action against an accountant, lack of privity is a viable defense if the plaintiff, A, is the client's creditor who sues the accountant for negligence. B, can prove the presence of gross negligence that amounts to reckless disregard for the truth. C, is the accountant's client. Or D, bases the action on fraud. So in a common law action against an accountant, lack of privity is a viable defense if the plaintiff is the client's creditor who sues the accountant for negligence. And then 19, liability to non-clients. 19 and 20, I'm going to have you take a look at these 2 on your own. And I will tell you that the answer to number 20 under the Ultramayor's rule, to which of the following parties will an accountant be liable for negligence? And Ultramayor says parties in privity of contract, yes. And foreseen parties, the answer is no. Foreseeable in a privity-like relationship, yes. But foreseen, no. The answer is B. And so the good news for accountants is that the plaintiff has the burden of proof, and you can protect yourself by complying with your professional standards, using good professional judgment, and using a letter of engagement that clearly states the relationship that you have with your client. And then finally, you should not rely on this, but this is important. The purchase of adequate malpractice insurance is also very important. Not a substitute for hard work and good judgment, but it is important. Next class, we will finish Module 23, and so I'll have you prepare these questions. Thank you so much.